And she opened the door and she pointed the gun directly towards my face and between my head and my neck and said, "Bitch, I will shoot you." I had my cell phone in my hand to film because she's never pulled a gun, but she's just been antagonizing so much. I had my cell phone with me to film because I knew that I needed to show the police this. And after she did that, and I guess she realized that she was being filmed, she ran in the house. The boyfriend was still standing there. I said, "This has been going on for over 2.5 years. He's just standing there not saying anything." She ran back in the house and put the gun there. When she came back to the door, she opened the door, she ran out. She picked up a rock that was by her porch, about the size of my hand. She took the rock and she threw it at me. When the rock did not hit me, she then picked up a sandal.
This is on the People versus Larkins, please.
Good afternoon, Your Honor. Mohammed on behalf of.
Good afternoon, Your Honor. Teresa Tucker, PA 5402, on behalf of Sheila Larkins.
Have a seat, ladies. Are we ready?
Yes, Judge, I'll request a mutual order of sequestration with an exception to the officer in charge.
All right. Ladies, you're not prospective witnesses? Back row, are you witnesses?
He's the victim and then
Okay.
the victim advocate.
Okay. All right, let's get started.
The people called Kelly Massey.
Ms. Massey, all the way up front. All the way up here. Watch your step on the incline ramp right here and raise your right hand. Raise your right hand. You swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
Have a seat right there. When you're ready, Mr. Muhammad.
Good afternoon, Ms. Massey. Can you please restate your full name for the record?
Yes, my name is Kelly Massey.
Okay, Ms. Massey, I'm going to take you back to the date of November 24th, 2024. Were you at or near the location of 16857 Howick Lane? And for the record, Howick is spelled Hawick.
Yes, I live next door at 16869 Howick Lane.
Okay, and is that located in the city of Romulus, County of Wayne?
Correct.
Okay, did something happen at or near that location that brings you into court?
Yes.
Okay, how did that begin?
On that day, I opened my window downstairs, window next to the door,
So where were you?
in my living room.
Okay, at your home?
Excuse me?
At your home?
Yes, inside of my home,
Okay,
in my living room. I opened my window and I looked out, and my lights that I have in the ground and around the perimeter of the mosque, the lights were broken. That was not the first time the lights were broken, because she had broken them before, but I noticed that day more lights were broken. So I just shook my head. I knew it was exactly what was going on. I went upstairs as I was ready to start work that day at 1 p.m. So it was time for me to get in the shower and get myself ready for work.
Hold on. Something's wrong with our equipment.
Stopped.
I'm gonna stop this and start working. It's saying what she previously said.
good job. Nice to spoke of this.
No equipment, for some reason, it's just replaying. Stop, it's not recording, it's just replaying. It's replaying in my ear. I did. Yeah, let me try it now, turn up again. Let me turn it on. Okay, good. All right. Listen. Okay, talk.
Okay, is it testing, recording?
Yep, perfect.
Okay, all right. Sorry about that, Miss Massey. So Miss Massey, I think you said you were headed upstairs to get ready for work.
Yes. So I proceeded upstairs to my upstairs bathroom to get in the shower and get ready for work. After I got out of my shower, I'm in my bedroom getting dressed, and I just happened to glance out the window, and that's when I see Sheila Marie Larkins in a black bra and a red plaid schoolgirl skirt, holding her barbecue grill, running full throttle charge through the yard toward my windows, my downstairs window. That's my little window. And I yelled out, I said, "What are you doing?" And she said, "I will tear this whole effing yard up." And she took the grill, and at that time, I seen her just running, and I started coming downstairs to go to my door, because I thought she was going to bust the window out with the grill. When I got down there, she took the grill and she threw the charcoal ashes all across my window. And as I'm coming outside and I'm walking to her over to her towards the main part of the sidewalk, more towards her side of the yard, that's when her boyfriend was standing there in the matching pajama pants to her skirt and his robe. And then she opened the door and she pointed the gun directly towards my face and between my head and my neck and said, "Bitch, I will shoot you." I had my cell phone in my hand to film because she's never pulled a gun, but she's just been antagonizing so much. I had my cell phone with me to film because I knew that I needed to show the police this. And after she did that, and I guess she realized that she was being filmed, she ran in the house. The boyfriend was still standing there. I said, "This has been going on for over 2.5 years. He's just standing there not saying anything." She ran back in the house and put the gun down. When she came back to the door, she opened the door, she ran out. She picked up a rock that was by her porch, about the size of my head. She took the rock and she threw it at me. When the rock did not hit me, she then picked up a Santa's mailbox, a metal Santa's mailbox with
A what mailbox?
a metal Santa's mailbox
What's a Santa's mailbox?
Yard decoration.
Oh, okay,
for Christmas,
okay.
for Santa Claus. It was porch decor. She then picked that up. It had a candy cane handle about that big. And she took that and she threw it at me. It did not hit me. When she didn't hit me with the metal Santa box, she then grabbed the barbecue grill top for her grill that she had already thrown toward the window. And she threw the barbecue grill top at me. And it missed. I blocked it with my hand. At that point, she has come further from her porch, so she's now on the common sidewalk. At that point, she ran out of things to throw. And then she came, she had her hands up, I put my hands up, and then it was mutual combat.
Understood. Now, the firearm that was pointed at you, can you describe it?
It was black. I can only see the front of it. I never got a side profile of the, because by the time she came and opened the door, she had it pointed directly at me.
Okay, can you describe what kind of gun? Was it like a long gun, a shotgun, a handgun? What
It was a handgun.
Okay,
It was a handgun because she had it in her hand. But I only see the front profile of the gun.
okay, so black handgun.
Yes.
Okay. Now, this individual that you mentioned, Ms. Larkins, the person who pointed this firearm at you, do you see this person in the courtroom today?
Yes.
Can you please point to that person and point out a piece of?
Well, I can't tell you because I've never seen her with that hair. The hair that she had was blue dreads. The natural hair is blue dreads, and I've never seen her with glasses on.
Okay, so, but do you see that person in the courtroom today? The person who,
Pull the gun?
yes,
No, I see a person that had gray roots with blue dreads No glasses.
Okay. Judge, I would request for the person sitting at the defense table to remove their glasses and maybe that assist in identification. And to just move their hair away.
Oh, no objection, Your Honor.
Judge,
What's your objection? We've asked her to show her face.
She is showing her face. Her taking her wig off is,
That wasn't the question. The question was, could she move her hair off of her face?
and I never said it was a wig, but I'm assuming based on your statement, it is a wig. I just asked it because for the record,
Counsel, I don't think it's asking too much to be able to see her eyes when there's an identification at issue. Thank you.
okay, take a look in the courtroom and see if you can, if that person,
That's the one face in the yellow jacket.
how do you know that?
I can see the face profile now without the glasses. And I'm pretty sure that there's blue dreads, or she may have died with their dreads under that wig.
Okay, Your Honor, purposes I'd respectfully request the court.
I'll note there's been an ID.
Know that there's a. Okay. And when this firearm was pointed at you, how did you feel in that moment?
I felt like my life was hurting.
Okay,
I was scared. My heart was beating.
okay. Nothing further.
Counsel, your witness.
good afternoon, Miss May. Is it Macy?
Maxie, MASSEY.
Okay. So, you just testified that, Ms. Larkins threw things in your French oven.
No, she threw those things at me. She threw the rock, she threw the mailbox, and she threw the barbecue.
We're not that far. You said you got out of your shower and you looked outside and Ms. Larkins was coming at your front door, correct?
No, she was coming at the living room window
Okay, living room window, with an object,
with the barbecue grill,
a barbecue grill.
her barbecue grill.
Okay. And you just testified that when you were outside, you saw Miss Larkins pointing a gun from her house.
When I was outside, I saw Ms. Larkin pointing a gun at me from her doorway.
From her doorway inside of her house.
No, she had the door open. She was standing in the doorway, but the door was open.
Okay, but was she in her house?
She was standing on the, I guess, the bottom of the door. That's where she was standing,
In her doorway.
in her doorway.
Okay. Did you try to get in Miss Larkins' house?
Absolutely not.
Did you tell, Miss Larkins during that argument to go get your gun?
Absolutely not.
You just testified that you feared for your life, correct?
Correct.
Okay. But you didn't leave, correct? Meaning you didn't go back in your house.
I was standing on the common part of the sidewalk.
Did you go back in your house? Yes or no?
No, I didn't have opportunity to.
Okay, so you just testified that Miss Larkins closed her door and went and put the gun away, correct?
Correct. And
Okay, so in that time, you didn't go back in your house,
at that time, I stood there talking to her boyfriend who was standing there.
but you did not go back into your house, yes or no?
No,
Okay, then Miss Larkins came back out without that gun, correct?
she came back out.
Okay, and you and Miss Larkins then proceeded to fight, correct?
No, I was standing there. I thought my phone was still finished. So I was still standing on the common part of the sidewalk. She came out of her house after she put the gun in the house. It was only seconds. So it wasn't like it was minutes went by. There were seconds that went by. She opened the door, ran out in her bra and schoolgirl skirt with no underwear, bent down, picked up a rock the size of my head, threw the rock.
Okay, so again, you had time to speak with Miss Larkin's boyfriend, correct?
Can you repeat that?
You had time to speak to Miss Larkin's boyfriend, correct?
Yes.
Okay, but you didn't go in your house, correct?
No.
Okay. Miss Larkins allegedly threw things at you, correct? Rocks and signs that was in the yard, Christmas decor, correct?
No, she threw a rock, she threw a metal Santa's mailbox. Then she
That
threw
is Christmas
her,
decor.
then she threw the top to her barbecue.
Okay, it's still Christmas decor. Then after that, the two of you had, got to fighting, correct?
Correct.
Okay. And then,
She came to
Hold on, lady, counsel, really? You need a minute?
no, you're not.
You just answer the questions that are asked. Don't volunteer. Question is,
After the fight, did you go back to your house?
Yes,
Okay. And their police came and spoke to you, correct?
correct.
Did officers tell you that there was a 911 call of you trying to get in her house? Miss Larkin's house?
No.
Okay, no further questions.
Mr. Muhammad,
Very briefly. How long have you been neighbors with Miss Larkins?
I moved to 1689, well, excuse me, 16869 Holiday Lane on December 28th, 2022.
So approximately 2 years prior to this incident?
Correct.
Okay. And during that time, how many times would you say, if you know, are you very interactive with this neighbor?
No. From the first time I moved there was pounding on the wall in the living room. We found it strange, my movers came concerned, like what's going on. They left early. As that happened, it continued to get more frequent with the beating on the wall that happens mostly in the bedroom. It happens through the night. After it happened for so long, I then contacted the owner of the condo to ask whether there were any issues with the prior tenant that lived in my residence.
Okay, I guess my question is, have you seen this defendant before?
Yes,
Before this interaction?
yes,
Okay, and so are you familiar with her face?
yes, I am.
Okay, and that's the same person that individual is, you're the same person that we had in the courtroom?
Yes,
Okay. All right, nothing further.
any recross?
No, Your Honor.
Ma'am, you can step down, watch your step on my incline ramp.
No further
Yep.
questions.
Thank you. Any defense witnesses? Ms. Tucker?
No defense witness, Your Honor.
All right, I'm ready for argument.
Judge, I'm going to motion for a binding where I believe the testimony reflects the question of fact for the trier of fact. There actually is rebuttals.
Ms. Tucker, argument?
Yes, Your Honor. I object to the bind over on this, case of, Your Honor. Miss, Macy didn't fear for her life. Miss, Larkins did not step out of her house, Your Honor. Miss Macy stayed outside and waited till Miss Larkins came out in without said gun to where they then proceeded to get into a fist fight, Your Honor. So we object to the bind over.
Mr. Muhammad?
Judge, I believe the testimony by the witness was that she didn't feel in fear. He indicated that there was a gun pointed in her direction, and I believe the testimony reflects a question of fact.
And that was the only testimony put in front of the court. Bound over. AOI 2 weeks from today, 9 a.m. Bond is continued. Good luck downtown, ladies. Do we know if Mr. Bryant is here?
Yes.
Oh,
I believe all.
do we know if the attorney's here?
That I don't know, but I do have all.
The attorney would be Margolis.
all.
Right here, this is where things take a seriously unexpected turn. Up until now, the courtroom has been focused on testimony and evidence, but suddenly, the spotlight shifts to something just as critical: legal representation. Think about it. A defendant is sitting in court, in custody, and their own attorney doesn't even show up? That's not just a scheduling mistake. That can impact someone's entire defense strategy. And watch the judge carefully here. There's no chaos, no panic, just calm control. She immediately pivots, verifies the situation, and starts fixing the breakdown in real time. But here's the bigger question for you. How much damage can a missing lawyer actually cause in a live court proceeding? Because in moments like this, timing isn't just important, it's everything.
No shows.
We got everybody here but the defense attorney on this.
What a surprise. You got a phone number?
I think you're good. I was just gonna say, I knew you was gonna get on that.
She didn't get rattled at all. But she objects to the bond overall with no testimony.
I didn't hear what she said. Check what was she saying?
She's trying to talk over me.
Oh, she's very, like, she should be getting excited like that. She's an attorney.
Well, just get excited if you want to. Just don't get excited with,
Hi, this is Heather calling from 34th District Court Judge Oakley's office. Is Mr. Margolis there? 34th District Court, you had an exam at noon today in our court at 34. Xavier Bryant.
Mind about these two? It's enlightening you.
Yeah, December 30th, you appeared on Zoom and you requested to have today as an exam. Did you speak to your client? His name spoke to his client.
Oh, God. Bring Brian in.
I'm sorry?
Bring Brian in, please.
Okay. Let's bring the prisoner.
He didn't write it in his book, Judge. So what do you know?
We're gonna have to adjourn it.
Right. We have next week at 1 o'clock.
How's it going? Make sure Mohammed's coming in, would you? We got him. The attorney's on the phone. He's at his office. He forgot to be here today.
You want Mohammed now?
Yeah. We gotta pick another date.
That's, yes, February 12th at 1 o'clock at the 34th District Court in Romulus. And your client is still in custody, so you know. Thank you. It's not, you don't have to tell us you're sorry. You need to contact your defendant. All right, thank you.
Would you like Mohammed in here, Judge?
Yeah, we're ready. Mr. Brian, just have a seat, sir.
He's aware of the notice, it's just not, it's never wrote it in his book.
Mr. Mohammed, your appearance on the People versus Xavier Bryant, please.
Good afternoon, Your Honor. Mohammed on behalf of the people.
All right. So for the record, this exam date was scheduled on December 19th. Well, Mr. Bryant and his attorney were present.
December 30th.
Oh, December 30th. Yeah, at our last PCC. Heather just called the attorney's office and he forgot to put it on his calendar. So we're gonna have to reschedule. Are you available, or whoever your witnesses are they available next Wednesday? We've given counsel a time slot next Wednesday at 1. I just want to make sure your witnesses are present.
You should be available, Judge.
So the defendant hearing of Brian. The court wants to make sure that next.
I just want to make sure you guys aren't in training or on vacation or anything next Wednesday. You're all available?
Yeah.
Gang's all here? Okay. I know where you're at. Sorry. So we'll see you next Wednesday. All right, questions?
Nothing would be moving.
Would you want representing?
No. Your attorney's not here today because your attorney forgot to put it on his calendar.
I would like no counsel. I haven't learned that I take the part.
You mean you're gonna hire somebody? Have that person file an appearance yesterday. I mean, have them do it soon. All right,
We'll have to set for an exam if that's.
let's leave it there and then the new attorney can contact you if that's a problem.
Oh,
Right. We got to see an appearance before we do anything.
oh, yeah.
Yeah. So have the attorney you've hired, have them file an appearance so that everybody in the system can talk to them as your attorney. All right?
I'm here.
I hear you.
You know,
All right.
Yes, you show that I don't have a specific name yet, someone from that company instead of the budget.
Okay. Who'd you just talk to?
Margolis was appointed.
From NDS.
No, not, yes.
He's
he
not.
was appointed through the
Okay.
indigent fund.
All right. All right. It wasn't Mr. Margolis. That's not the name?
Rather,
Yeah. That's the guy that you talked to Margolis back in December, right? Okay. So that's who we just talked to that's not here. So if you got somebody else that's coming in, they got to file paperwork. And then he can legally talk to them about it. All right? All right. We'll see you next week.
thank you.
All right. Sorry, guys. Be safe.
Speaking sort of.
Who knows? Yeah. That just kills me.
And
I mean,
he hasn't spoken to his client since.
Yeah. Yeah. And he's gonna, and they're making good money.
So I just wanted to ask, like, what was this today? The process being reviewed, she doing fixing that she lost. Yeah. I had it in the rules that the cases of registry as a over show, but then he was charged the years. So I'm not sure why that changed it, but she's here. So the process being next to me, but she wants to. It'd be fine. So I asked her family great, listen, she's here today, but she does want to.
She wants to know, so.
Yeah, but she does want to appear in person, so I'm gonna ask that if there's a way this kept on her docket saying that we want this in person.
Yeah.
It's easier for her to appear.
No, that's fine. That's fine, yeah.
Thank you, Judge.
Just gonna figure that, we would sometime.
Sounds good, Judge.
All right. Well, we're just gonna set another pretrial?
And then I think he needs to be arraigned on the 25 case.
Yes, Judge.
Yes. Yes. I don't have a 25 case. I got a December 24 and I got a,
No, the 25 case is in the case number.
oh. Got it. Yeah, and how did we do? Oh, okay, that's why it came in 2025, but it's a 24 incident date.
Yes.
All right. All right, so let's get appearances on Leslie Morgan.
Morning, Your Honor. Patricia Mandrack for the people, the 840
May it please the court, on my left, the 5634 for the record.
Leslie Morgan.
Thank you. Counsel, would you waive formal reading on the 12/21/24 incident?
You do waive formal reading.
I'll enter a not guilty plea. All right. So we're going to adjourn a pretrial out till March 19th?
March 19th.
If they're coming back to us, they
Yeah.
want 6 weeks, just for a pretrial, yes.
March 19th?
I'll be in a trial that starts that Monday.
How about the week after? 26th?
Early morning or later morning?
You said which day? I'm sorry.
26th.
We have starting at 8:45 all the way to 10:30.
9 o'clock, please.
As well, I was expecting to request that in favor of the litigants, presence day. Wait for that pre-trial.
Done.
Thank you.
All right, so on the April 10th incident date, we'll just continue bond. Let's talk about bond on the newer incident.
This is where things get really interesting from a legal standpoint. The judge is now setting bond conditions. And listen closely, because this is more than just routine. No contact means no contact. That's not just a suggestion, it's a legally enforceable boundary. Calls, messages, social media, even indirect contact through friends, it's all off limits. And the way the judge explains it, crystal clear, almost like she's eliminating every possible loophole before it even happens. This is actually a smart judicial move. Because ambiguity in court orders, that's where violations happen. So by spelling it out in plain language, she's doing two things at once: protecting the alleged victim and making sure the defendant fully understands the consequences. And now the pressure is real, because one mistake here doesn't just break a rule, it creates a new criminal problem.
Judge, in this case, for the malicious use of telecommunications device case, I am requesting that I am going to leave the terms of bond at the discretion of the court. I would ask that another no contact order be entered. And I would ask that the court reiterate to the defendant that this is a complaining witness contact, and if had no contact with them.
Okay.
Mr. Morgan does understand that they have contact with her. However, she does, and he showed me her, and I showed that to the prosecutor. She does what amounts, in my opinion, to harass him and his wife. Like 100 calls a day type stuff. And so we would ask the court to maybe admonish her.
She's not under my thumb. She's not under my thumb.
And Judge, I haven't talked to the complaining witness about this.
Right. I think it's ill-advised behavior, but I don't have her on a bond. Yeah. But I want to note for the record that the no contact order, at least according to my records, was entered on December 24th. The telecommunications charge came out of December 21 incident date. So I don't hear any allegation that the bond on the first file was.
That's correct, Judge. If the defendant had been arraigned on the day before, this conversation would be very different.
Yep. Okay. All right. So what I'm going to do is I'm going to mirror the bond on the second file as to match the first file. No contact, no phone calls, no letters, no social media contact. You see her Taco Bell, you're eating Burger King. Don't have your friend call her and see how she's doing. She tracks you down and begs to meet for coffee. She can't change this order. Only myself or somebody else with a rope. Clear enough? Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you violate bond? That's condition 1. Condition 2 is no other trouble, no new criminal offenses. And condition 3, you got to be in court for March 19th.
Yes, sir.
Agreed? Anything else, counselors?
I believe you said March 19th?
March 19th at 9. Oh, I'm sorry. We talked to 19th and we moved it. Good catch.
Thank you.
Have a good day.
Oh. Okay.
For you and for your client.
Counselor, are we ready on Mullins?
Mr. Mohammed, I'm doing what? No, I don't.
How's Miss Henderson today? I said, how's Miss Henderson today?
Yeah.
Wonderful. Are we holding this one?
All right, thanks. Have a good one.
Sit.
Yeah, we will hold on.
Yeah. You got
I asked you to email here.
Hey, Ken, you have to be here tomorrow.
I'll be here.
People are on.
Believe me, I always should.
What look you like?
Well, he was worried that you'd try to get out.
I didn't say that. Well, I didn't even have to wear leggings under a skirt.
We ready? Mr. Mohammed?
Yeah.
All right. If you two would put your appearances on the record for Mr. Ray Mullins, please.
Good morning, Your Honor. Mohammed on behalf of the people.
Good morning, City Anderson with the Neighborhood Defender Service, P84839, appearing on behalf of Ray Mullins, President of Courtroom today. Can you please state your full name for the record, sir?
Thank you. Have a seat, Mr. Mullins. The attorneys are trained to jump up in law school. You don't have to do that. Are you ready, Mr. Muhammad?
Yes, the people called Officer Kuzar, my apologies.
Corporal, come on up. Watch your step on my ramp. Raise your right hand. Swear affirm to tell the truth, the whole truth, nothing but the truth.
I will.
Have a seat. You know the drill. Settle in. When you're ready.
Good morning, Officer. Can you please state your full name for the record?
Nathan Kuzera.
Officer, I'm gonna take you back to the day of September 2nd, 2021. Did you work that day? And in what capacity did you work that day?
Road Patrol.
Okay, and who's your employer at that time?
City Road.
Okay, and in what capacity did you work for them?
The Road Patrol.
Okay,
Police officer.
okay. And on that day, did you work by yourself or with a partner?
By myself.
Okay, and did you work in full uniform or modified uniform?
Full.
Okay, and on that day, did you operate a scout vehicle or did you work foot patrol?
Scout.
Okay, now was the scout vehicle fully marked or semi-marked?
Full work.
Okay, and on that day of September 2nd, 2021, did your duties as a police officer take you at or near the location of North Line and Huron River Drive?
Yes.
Okay, is that located in the city of Romulus, County of Wayne?
Yes.
What took you to that location?
Let me stop you, Mr. Muhammad. You don't know this, but we do. Which North Line in Huron River Drive?
The North Line and West here.
Thank you.
Thank you. And what took you to that location?
Dispatch location. To be an accident.
Okay, and when you made that location, what did you do?
On arrival, I saw actually the step back. It was a reference a green Yukon and a blue Ford Explorer that was involved in the accident. No injuries reported and being reported off the side of the road. Upon arrival, heading west on Huron River Drive, and I got behind the vehicle that was on the westbound side of the road, which ended up being a blue Ford Explorer.
Okay, and you indicated that there was a traffic accident. And did you observe any damage to any vehicles when you made that location?
Yes, there were two vehicles there. The green Explorer, or green Yukon, and the blue Explorer. I was very damaged to.
Okay, now when you made that location and you made those observations, what did you do?
First contacted the Explorer.
Okay, now how many individuals were seated in that Ford Explorer?
One in the front drivers.
Okay, and describe the scene.
The vehicle.
The vehicle, anything that you saw.
White male sitting in the front driver's seat, the airbag was deployed. The obvious damage to the vehicle from the vehicle.
Okay, now the individual was sitting where exactly?
In the front driver's seat.
Okay, now the individual you observed in the driver's seat, you see that person in the courtroom today?
Yes.
Can you please point to that person and point out an article of clothing that person is wearing?
Sitting at the defense table.
Can you please point out an article of clothing?
Black sweatshirt.
Your Honor, please let the record reflect the witness has identified the defendant.
No,
Thank you. And so then what happened next?
I asked the driver if he was okay. She tried to reply he was, then asked him for his driver's license, registration, proof of insurance.
Okay, and what happened next?
I could smell the odor of the toxins coming from the person,
Okay,
and I seemed to kind of fumble for his driver's license. When he's pulling out his wallet, he wasn't able to hand me his driver's license. While he was looking for his insurance and registration, I also asked him for his phone number to write down the report. The driver was able to only give me 3 of the last 4 numbers of his phone number.
okay,
Then at that point, I asked him about that. There was only 3 numbers, and the driver then stopped and looked at me and stated I'm drunk.
okay. Stated what?
I'm drunk.
Okay. And then what happened then?
Made sure he was okay. Believing that the vehicle was disabled, he wasn't going to be able to go anywhere. Asked him to relax, stay there at that location. So I go talk to the other driver, find out what happened. Then I was able to talk to that driver, get all their information, return to my car, wrote down the information I needed from that driver, gave him a business card, was able to clear him from the scene when she was able to drive his vehicle. And then I went back to Mr. Mullins to speak with him.
Okay, and so what did you do next?
At that point, I requested that Mr. Mullins step out of the vehicle,
Why did you do that?
believing he was impaired. The
Okay, what led you to that?
snow intoxicants from his birth. Fumbling for his driver's license. And telling me that he was drunk, which is kind of abnormal, especially at that time of day. And being behind the wheel of the car.
Understood. And so what happened next?
I asked him to.
Bless you.
Sobriety test. He said he wasn't sure if he could, he was cooperative, and he was able to exit the vehicle. He appeared a bit unsteady on his feet as he walked towards the back of the car. I asked him to step the back bumper of his vehicle, perform the sobrieties. Excuse me. I asked him which grade he was able to complete it, and if he was able to read. He said he understood the alphabet. At that point, I asked him to recite the alphabet and stop at the letter P. He continued to the letter S, and then I asked him again about the alphabet, and he refused to complete any word.
Okay, is that indicative of anything based on your training and experience as a police officer?
Yes, it's not too often that people are actually that honest, but he appeared to be fairly impaired at that point, and I'm unwilling to complete any more sobriety tests.
So besides the alphabets, were any other tests conducted?
I was also able to administer a preliminary breath test at
Okay,
the scene, which he consented to take.
okay, and I believe the results of that is inadmissible in court, so we'll move on. So what about any other tests besides the test?
No.
Okay, and did you recover or observe any items from the vehicle?
Yes, there were, you referred my report real quick.
Will it help refresh your recollection? Officer, with referring to your report, help refresh your recollection?
Yes.
Okay, you can refer to your report once your memory's been refreshed.
Okay.
So go ahead. Has your memory been refreshed?
Yes, there were 2 unopened 40-ounce bottles of Budweiser in a front passenger seat of the vehicle.
Okay, and pursuant to your investigations, did you learn how much the defendant did drink?
When I asked him to step out of the vehicle, I asked him how much he had to drink. He told me he had 4 beers.
Okay, and so what did you do next after you conducted the field test?
I arrested him for suspicion of driving under the influence. Secured the backseat of my patrol vehicle.
Okay, and what did you do after that?
Transported him to the Romulus Police Department.
Okay, and what about after that?
He read his chemical test rates and he consented to a blood draw.
Okay, and did you transport him to get his blood draw?
Yes.
Okay, and was his blood drawn?
Yes.
And did you observe the blood draw? Okay, and what did you do with that after it was conducted? Was it placed into evidence?
Yes.
Okay, Judge, at this time I'd move to introduce into evidence the MSP lab report that shows the blood draw results of the defendant pursuant to 76611.
Ms. Henderson, thank you. That'll come in.
No further.
Your witness, counsel?
I have a follow-up question for you. You indicated that you were able to observe the blood draw, right?
Yes.
And when you observed the blood draw, you were able to observe the methods that the nurse, I'm assuming.
Yes.
And can you briefly describe what those methods look like?
Mr. Mullins sat in the chair. He, the nurse or phlebotomist, drew 2 vials of blood from his arm. Each vial was placed in the evidence container, evidence box, and sealed prior to leaving.
This right here, this is a textbook legal clash. The defense is attacking a critical weakness, missing evidence of prior convictions. And this matters a lot, because for a charge like a third offense OWI, those prior convictions aren't just background, they're essential elements of the crime. No proof, no complete case. It's that simple. But then the prosecution pushes back with something powerful, judicial notice. That means the court can recognize its own records without needing formal evidence introduced. So now it becomes a legal debate. Does judicial notice replace the need for proof, or is it not enough at this stage? And this is the kind of moment where cases can turn completely, because it's no longer about what happened, it's about what can be legally proven.
Hospital.
And did she do anything, he or she do anything abnormal or out of the ordinary in regards to?
Not part of it all, no.
Okay, we're going to take you back to the scene of the accident. When you arrived at that time, the cars were already parked, right?
Correct.
So you didn't actually observe anyone driving?
No.
Did you check for any cameras in the area that day?
I didn't check, but I don't remember if there are any cameras in here.
Were there any other individuals on the scene that day? Aside from Mr. Mullins, whom you say was at the scene, and the driver of the other car?
That responded to the accident itself. No, I don't recall anybody else being there besides myself and partners involved.
Mr. Muhammad, any redirect?
No, thank you.
Corporal, you can step down, watch your step. Any other witnesses from the people?
No.
Any defense witnesses?
No.
Argument?
Judge, I believe the testimony reflects the question of fact for the prior fact. I believe, based on the testimony of the officer, the defendant himself indicated to the officer that he was drunk, and then also the lab results show that he was the only occupant in the vehicle. The officer indicated that the airbags were deployed and this person was in the driver's seat. So I think there's sufficient evidence for probable cause.
Ms. Anderson?
Yes, Your Honor. At this time, Mr. Mullins is currently charged with felony local DUI. To prove the elements of this third offense, felony OWI, the people would have to produce some sort of evidence that Mr. Mullins was previously convicted of some sort of operating while intoxicated. We didn't hear any testimony today. I wasn't providing any documents in regards to any convictions that Mr. Mullins would have had. Given that information, I don't believe that the people have met their burden for dismissal.
Judge, it's implied when it's in the complaint, and this isn't a felon in possession charge case where we have to get a certified record of actions. I've never, since I've started as an attorney, as a prosecutor, seen a case where I have to present the prior convictions.
Is it not an element of the crime? Prior convictions?
It's implied based off of the habitual offense notice in the complaint.
Is it not an element of the crime?
It is.
And doesn't each and every element of a crime have to be proven beyond a reasonable or beyond probable cause today? Because I think she got you.
I don't think so, Judge. I've never heard of it.
It's a probable cause hearing.
Well, I would ask the court to take judicial notice over their own records of the defendant.
Your Honor, at this time, I would also note the court did not check the register of action, and there is not, despite what the complaint indicates, there is not a second conviction in 2012 for a conviction for Mr. Mullins, which is why I was ready to see some sort of conviction record of Mr. Muhammad. Today, but I haven't seen that, and I don't think the court can take, judicial notice. any convictions in the register of actions, because there's one conviction in the register of actions from the 2022 date.
Well, Judge, I would just point the court to see that in the complaint that we have in front of us, the OWI that occurred on September 8th, 2011 happened at the 34th District Court. Furthermore, the second conviction that we have, the one that occurred on 07/13/2020, occurred at the 34th District Court. So in this case, both previous convictions were at this very court. So I think the court, if any court can take judicial notice, it would be this court, because both convictions happened and stem out of this court.
Response.
Again, Your Honor, I've checked the register of actions, despite what the complaint says, there isn't a conviction in the register of actions for the 34th District Court noting the conviction in 2012, or any sort of operating while intoxicated. Furthermore, there was no evidence presented today, which is what Mr. Muhammad had the burden of proof today.
Okay.
That there were.
So let me make sure, sorry to cut you off. Let me make sure I understand your argument. I think what you're saying is, even if our computer records show 2 prior convictions, there was no evidence of it today.
Right.
Your turn.
Well, Judge, that's why I'm asking the court to take judicial notice over their own records, and these prior convictions, these 2 occurred in this court. It didn't happen in a year.
No, I got you.
So that's my request.
All right, well, let's see what our ROA says. We have 2? Give me the dates.
I'm sorry.
The dates? Oh, you're just gonna print them out?
That's the first one. Here's the beginning of the second one.
All right, February 2, 2012. Plea of guilty. January 7, 2021, plea of guilty. So I will take judicial notice that our internal records show 2 separate guilty pleas from Mr. Mullins, just 2 separate charges. Actually, I'll give you the incident dates as well. One incident date was July 13, 2020. One incident date was September 8, 2011.
Thank you.
I'm still not sure you don't have to have evidence of it beyond judicial notice, but
And there it is. The judge makes the call. She accepts the internal records and moves the case forward. This is a classic example of judicial discretion in action. The judge acknowledges the uncertainty, even hints that the decision could be challenged, but still decides there's enough to proceed. That's the key difference here. This isn't a final verdict. This is about probable cause, not proof beyond a reasonable doubt. And did you catch that subtle line? You can appeal me. That's confidence, but it's also transparency. Because in the legal system, decisions aren't just made, they can be tested. So now the case moves forward, but the real battle? That's still coming.
I'm going to bind it over and Ms. Henderson can appeal me and tell me I'm wrong. Clear? Anything else? Good luck downtown, Mr. Mullins. We'll get you a AOI date for 2 weeks down the road. But we don't give them a paper notice anymore. So your next court date's downtown 2 weeks from today, 9 a.m. Bond is continued. I'd like the attorneys up here when you're done with your client, Ms. Henderson. Any chance of that getting pled down downtown?
Yeah, I'm
Back to a
gonna
misdemeanor?
put a case note. I could have swore I
He's a Belleville guy. We got a great sobriety court program.
here.
I just took it over January 1. So I'm just throwing that out there for the 2 of you.
I wish.
You know, I'm cocky enough to think that we do a better job here than what they do downtown, so.
Okay. I would I wonder if we can like keep it here even though it's too late.
I mean, I'm still gonna write mitigation information once I get over there to have it reduced, so.
Yeah, but if it's still here, I can go to my chief, talk to him face to face and be like, hey, this one, it's. But I'll put a case note.
I can't figure out how I would keep
And
it
plus, I
now.
would rather keep him here because.
Well, he lives in our venue, so.
Yeah,
I'm
yeah.
assuming if downtown wants to put him in sobriety court, they're probably gonna want him in ours, I would think. I don't know.
Just make that request.
And I'm not saying he's eligible.
No,
I just,
because
the first thing we look at is where he lives, right? If he was living in Pontiac, we wouldn't even consider it.
No, and they're older and stuff as well. The only reason I didn't unilaterally reach out to my supervisors because we had no CCH in our system for this case.
I'm not blaming anybody for anything. I'm just throwing that out there because we're trying to build up our docket on the sobriety court, and this guy needs help, obviously.
Yeah.
Okay. All right. Good luck downtown. Let me know, Miss Henderson.
We have Mr. Starling Ellis.
I'm ready. We holding that one?
I think he's here.
Oh. Oh. I forgot that. Mr. Muhammad, let's talk about Mr. Sterling, who's in federal prison and Huron didn't go get him. Not that anybody thought they would, but.
Correct, Judge. So I was informed that the defendant is in federal custody. And my understanding is he has a release date, I think in April. And so I would request that we just adjourn it to that date. To a date in April.
Do you know what date? Too early, it's not here.
When I looked, it was, I think, towards the end of April, this is renewing dates.
So maybe the first court hearing in May.
He had an Illinois address on our file.
For another exam.
Yeah, we could just keep it as an
Ms. Ellis, can you hear me?
It's gonna be the
Yes.
same defense.
Good morning.
Good morning, how are you?
Excellent. I've got the prosecutor here and your son's attorney, Ms. Henderson.
Oh, yeah.
Can you, if you know, can you
As
tell
an
me when your
observer,
son
we
is
can use
supposed to be released
Hershey.
from federal prison? Ms. Ellis, can you activate your camera and or microphone, please?
27th, but because it's a weekend, he gets out on the 25th.
This is mom?
Yes.
Okay. All right, so what date would you?
Miss
propose?
Ellis?
So, just, Ms. Henderson, you want to go with a PCC or just keep with an exam? He had an Illinois address on our file.
There's Miss
Once
Ellis.
he's released, I can.
Ms. Ellis, can you hear me? Yeah.
Yes.
Okay. Good morning. We'll go with
Good morning,
the
how are
cause
you?
conference. May what? I've got the prosecutor here and your son's attorney, Ms. Henderson. Can you, if you know, can you tell me when your son is supposed to be released from the federal prison?
April 25th.
Can he, if he's out of state?
Thank
It was
you.
originally 27th, but
Mom,
because it's a
where's he gonna
weekend,
be
he gets
after he
out
gets
on the
released?
25th. He will be with me, he will stay with me in Bellwood.
Where's that at? All
Bellwood,
right, so what
Illinois.
date would you propose? All right. So is that the 734 Bellwood apartment GE? Ms. Henderson, you want to go with a PCC or just keep with an exam?
Now he's 2E.
Thank you. And how about a phone number?
I
don't really care. Got mom's number?
Maybe
All right.
PCC.
All right, so what I'm going to suggest is you.
Once he's released, I can contact Mitch.
Yes.
Yeah, okay. All right,
Yes.
so we'll go with the probable cause conference, May what?
Thank
Have a
you.
nice day.
You
Time?
too. Bye-bye.
Ms. Henderson, 10 a.m.?
That works.
All right.
Can he, if he's out of state, can you?
Mom, where's he going to be after he gets released?
He will be with me, he will stay with me in Bellwood.
Where's that at?
Bellwood, Illinois.
Okay. All right. So is that the 734 Bellwood apartment GE?
Apartment 2E. He used to stay in GE. Now he's 2E.
Thank you. And how about a phone number? Oh, Counsel, you've got mom's number? All right. So what I'm going to suggest is you be in contact with Ms. Henderson.
Yes.
All right?
Yes.
Anything else?
No.
Good luck, Mom.
Thank
Have a nice
you. You too. Bye-bye.
Thank you, Ms. Henderson.
No, you'll still have.
Yeah, we,
You're bigger version, and,
Larkins.
Oh, okay, thank you.
I'm ready. You as well, Counsel. Liberty. Files for Dill and Liberty, those are Nopes.
Mr. Liberty was on Zoom, I was chatting with him, and he said he wanted to apologize for meeting, but they were just setting up their meeting in let's look at on May 3rd, they were for bed. He served 45 days in defiance.
Good, okay. Treatment's wonderful.
Mr. Noakes, because then that way, as Mohammed said,
Mhm.
healthy.
Hopefully, yep. Those are the filter peers. I'm just waiting to see if our 12 o'clock show. You said Brian is here, right?
Yeah, Brian is here because he's in custody.
We've got two. Bryant and Larkins both scheduled at 12.